Most of us picture Election Day as one massive, unified event across the country. But practically speaking, the United States doesn't actually run a single federal election. It runs 50 completely separate, independent operations, managed state by state. Recently, the Department of Justice began systematically contacting these independent state officials with an unusual demand. They wanted access to the raw data files on American voters. That demand hit a sudden roadblock in Rhode Island, where a federal judge decisively blocked the DOJ from extracting the state's voter information. U.S. District Court Judge Mary McElroy sided with local election officials and civil rights groups. Her ruling was blunt, stating that the federal government simply does not have the legal authority to conduct the kind of wide-ranging fishing expedition it was attempting. This ruling in Providence is the latest flashpoint in a nationwide struggle. The outcome of these legal challenges will determine who oversees the voter files used to verify the electorate in the upcoming midterm elections. The push for voter files goes far beyond Rhode Island. Under the Trump administration, the Department of Justice has quietly sued at least 30 separate states to acquire their voting records. The effort has already gained significant ground. At least 12 states have willingly agreed to comply, turning their detailed voter files over to the federal government. But others have pushed back. Election officials in California, Massachusetts, Michigan, Oregon, and Rhode Island have successfully mounted legal defenses to protect their citizens' data from the dragnet. Because some states comply while others fight, we are left with a fractured national map where a voter's privacy depends entirely on their zip code. This uneven landscape forces a direct conflict between state autonomy and federal power. Under the U.S. Constitution, the federal government doesn't run the voting booths. State officials possess the exclusive mandate to administer their own elections. The executive branch cannot unilaterally rewrite those rules. Only Congress holds the legal authority to pass legislation dictating how states oversee the voting process. The administration, however, argues that federal intervention is a necessity for election security. They claim this nationwide data collection is required to prevent widespread fraud, pointing to Donald Trump's repeated, unproven assertions that the 2020 election was stolen. State leaders counter that handing over massive databases of personal information raises severe privacy concerns, while centralizing an alarming amount of oversight in the hands of the executive branch. These two competing views, an executive demand for security files versus a state's right to manage its own voting system, create a direct collision between co-equal branches of government that requires an outside referee. When the president and the states collide, the judicial branch is forced to step in and interpret the rules. Across the country, federal judges have established a consistent pattern of rejecting the administration's attempts to forcefully extract these voter files. Following the Rhode Island decision, Secretary of State Greg Amore praised the courts for halting what he called clear constitutional overreaches, noting that the executive branch was regularly meddling in the rights of the states. We are watching a live stress test of the American Republic. The system of checks balances is actively working as designed, with the courts establishing hard boundaries on what the executive branch is allowed to do. But with the judicial firewall holding strong and blocking the data requests, the administration has quickly pivoted away from the courts to find a new path forward. Blocked by federal judges, the political strategy has shifted to the legislature. The administration is now pressuring Republican lawmakers to execute a workaround through Congress. The result is the Save America Act. This proposed bill would mandate significantly higher documentation standards, requiring people to explicitly prove their citizenship when registering to vote and casting ballots. Proponents argue the law is essential to stop non-citizens from registering, yet multiple statistical studies have consistently shown that instances of actual voter fraud are incredibly rare. When you look past the stated security goals, the legislation functions as a strict administrative filter, placing high hurdles that directly alter who can access the ballot box. If these higher documentation standards become law, the immediate collateral damage falls on existing, lawful citizens. Critics warn the measure risks disenfranchising millions of legitimate voters who lack the specific paperwork. The logistical barriers are especially severe for people who have legally changed their names. Since taking a spouse's surname is standard practice in U.S. marriages, millions of voters suddenly face a massive bureaucratic maze when their identity documents no longer perfectly align. Both the aggressive DOJ data lawsuits and the legislative push for the SAVE Act are converging right as the country approaches the upcoming midterm elections in November. These specific midterms carry immense weight, as they will definitively decide the partisan makeup and legislative control of the United States Congress. The fight over a single spreadsheet of voter data in Rhode Island has evolved into a proxy war for the American Republic. As the executive, judicial, and legislative branches collide, the battle over the ballot is only beginning.